As the gun reform debate rages on, the Supreme Court has issued a major ruling on Second Amendment rights. In a 6-3 decision, the court struck down a restrictive New York gun law that forced people to demonstrate a particular need to get a gun permit to get a gun in public.
It won't immediately impact open carry laws in Texas, but has gotten a lot of attention from our politicians. Senator Ted Cruz was part of an amicus brief to the court pushing for this decision. He released a statement saying in part, quote, "This case's vindication of the right to carry a firearm for self-defense outside the home is an ever-present reminder of our duty as citizens to defend our constitutional rights." Here's a closer look at what this law says. With its conservative majority, the Supreme Court ruled against a New York law which allowed a person to carry a concealed gun in some places for self-defense, but only if the person proved a special need for it.
This decision isn't just reckless, it's reprehensible. It's not what New Yorkers want. And we should have the right of determination of what we want to do in terms of our gun laws in our state.
The case came out after 2 men in upstate New York were not able to get the concealed carry permits they wanted. They said it was unconstitutional. And during oral arguments, several justices seemed to agree.
Why isn't it good enough to say I live in a violent area and I want to be able to defend myself?
How is that consistent with the core right to self-defense, which is protected by the Second Amendment?
New York statute was different than the law in 43 other states where it is easier to carry a gun outside the home, including here in Texas. And we're joined now by Professor Emily Berman from UH Law School. Professor, I guess first question is, beyond the ruling saying at New York you lose today, what is the broader message this court has sent?
Well, it's raising a very high bar for governments to have to meet for any sort of regulation of firearms that they would like to implement. What the court said is that unless a legislature can establish that the regulation they want to impose is consistent with something that existed at the time the Second Amendment was adopted, so in the 1790s, sort of reason by analogy. Of course, they didn't have assault weapons or high-capacity magazines, but they might be able to look at, well, were there certain types of weapons, were the more deadly weapons of that age regulated, and was that okay?
In Texas, we already have open carry, like almost half the country, so does this ruling impact us?
That really opens the door for people to challenge any and all regulations that they don't like. And so I think we're going to be seeing the courts quite busy adjudicating Second Amendment challenges in the coming months and years.
And of course, gun reform debate big in the Senate right now. Any impact on that, you think?
I would say there's a similar impact there as in Texas. I don't think there's any particular provision in that bill that this specific case calls into question. But again, the very idea of how lenient, how deferential are we going to be to legislatures that would like to regulate guns? And this really sort of ratchets up the heat on that. And so again, we'll have to see what future challenges hold.
All right, sounds like we may be seeing a lot more legal cases coming through the court system on all of this. All right, Professor Berman from UH Law, thank you.